3 officers at the door. A piece of paper waved like a warrant, but no real warrant. They go in anyway, and what they find ends up thrown out of court. That moment, police forcing their way into an American home, the courts later refusing to use what they turned up, is not a legal technicality. It is the answer to one of the most important questions in criminal law. If the police break the rules to get evidence against you, can they still use that evidence to convict you? Before 1961, in most states, the answer was yes. The Fourth Amendment says the government cannot conduct unreasonable searches. It has said that since 1791. But for most of American history, the amendment had a problem. No one had figured out what happened when the police ignored it. The evidence was still there. The conviction still came. The right existed on paper and nowhere else. What changed that? What gave the Fourth Amendment actual teeth in a real courtroom was a search gone wrong in Cleveland, Ohio in 1957, and a woman named Dollree Mapp. Over the next 12 minutes, what happened at her door, what the Supreme Court did about it, and why the rule they created is still the most argued over protection in American criminal law. It is May 23, 1957. Dollree Mapp lives on the upper floor of a house in Cleveland, Ohio. On that afternoon, Cleveland police officers arrive at her door. They are looking for a suspect in a bombing case, a man they believe may be hiding in the house. They knock. Mapp does not let them in. She calls her attorney. The officers wait outside. Then they go in anyway. An officer holds up a piece of paper, waving it as if it were a warrant authorizing the search. Mapp grabs for it. The officers take it back. Later, no valid warrant will be produced in court. Whether one ever existed at all will remain disputed. But what is not disputed is this: no valid warrant was ever shown. A warrant, to be clear, is a judge's written authorization for a specific search. To get one, police have to show a judge they have good reason, what the law calls probable cause. It is the check on police power the Fourth Amendment was designed to require. A piece of paper waved through a window is not one. The officers search the house. They do not find the bombing suspect. They do find something else. Material they say breaks an Ohio law. They arrest Dollree Mapp not for anything related to the bombing, but for what the warrantless search turned up. She is tried, convicted, and sentenced under that Ohio law. And that conviction, not any bombing, not the suspect, is what eventually reaches the Supreme Court of the United States. But to get there, first she has to lose. And the reason she loses reveals a gap in American law that most people never knew existed. Here is the gap. The Fourth Amendment, as of 1957, already applied to the states. A 1949 Supreme Court case, Wolf v. Colorado, had settled that much. States could not conduct unreasonable searches. That was clear. What Wolf had not done was specify what happened next. If a state officer conducted an illegal search and found something, did that evidence have to be thrown out? Wolf said, not necessarily. States were free to handle the problem however they chose, and many states chose to use the evidence anyway. Federal courts had operated under a different rule since 1914, a case called Weeks v. United States. Weeks established what lawyers call the exclusionary rule. Evidence obtained through an illegal search cannot be used in a federal prosecution. The logic was simple. If the government breaks the law to get evidence and then uses that evidence to convict you, the court itself becomes a participant in the lawbreaking. But Mapp's case was in a state court, not a federal one, and Ohio was one of the states that, under Wolf was allowed to use what an illegal search turned up. The Fourth Amendment existed. The search was almost certainly illegal, and it did not matter. She is convicted. Her lawyers appeal. The Ohio Supreme Court upholds the conviction. Then the case goes to Washington. Her attorneys arrive at the Supreme Court primarily to argue about whether the state law she was convicted under was even constitutional. The exclusionary rule, whether the evidence should have been thrown out, is raised almost as an afterthought. Almost. Because the Supreme Court is about to do something no one in the courtroom fully anticipated. It is about to settle a much larger question than the one anyone thought they were arguing. On June 19, 1961, the Supreme Court issues its decision in Mapp v. Ohio. Justice Tom C. Clark writes the opinion of the court over 3 dissents. The court does not simply resolve whether the Ohio law is constitutional. It reaches back to Wolf v. Colorado, the 1949 case that had let states use illegally seized evidence, and it overrules it. After 12 years, the loophole is closed. The reasoning turns on a single principle. If the Fourth Amendment is a real right, there has to be a real remedy when it is violated. The exclusionary rule, throwing out the evidence, is that remedy. Without it, the court says, the constitutional protection becomes a form of words. A guarantee that no one can actually use is not a guarantee. The point is not to help guilty defendants. The point is to deter the police from breaking the law in the first place and to keep the courts from becoming instruments of constitutional violations. If you want to use evidence, get a warrant. Follow the rules. Do not force your way in with a piece of paper. The holding is straightforward. Illegally seized evidence is thrown out. The exclusionary rule now applies to the states. Every state court in the country is now bound by the same rule that federal courts had operated under since 1914. Where most criminal cases actually happen in state courtrooms, the Fourth Amendment finally has a consequence. Dollree Mapp's conviction is reversed. The search that started it all is ruled to have violated her constitutional rights, and the evidence from that search cannot be used against her. It is a resounding win, and it carries a cost that no one can ignore. The exclusionary rule does something that has troubled people ever since it was created. It can require a court to throw out reliable evidence that is true, that demonstrates what happened, because of the way it was obtained. In 1926, a New York judge named Benjamin Cardoso put the objection as bluntly as it can be put. If the police bungle a search, he wrote, the criminal is to go free because the constable has blundered. The guilty person walks not because the evidence was wrong, but because the process that produced it was. That tension is real, and it has never gone away. Defenders of the rule argue that the deterrence is worth the cost, that without the consequence, there is no reason for police to respect the warrant requirement at all. Critics argue that the cure sometimes punishes society more than it punishes the officer who made the mistake. The Supreme Court itself has spent decades navigating that tension. It has not stayed still. Later rulings carved out limits and exceptions to what Mapp established. Among them, a good faith exception for cases where officers acted on a warrant they reasonably believed was valid, even if it turned out to be defective. The rule today is narrower than it was in 1961, but the core holds. An illegal search can still sink a case in state court. The warrant requirement still has consequences. Mapp is the reason for that. What the case really established, what makes it more than an obscure procedural ruling, is that rights without remedies are fictions. The Fourth Amendment had existed for 170 years before Mapp. It took a forced entry, a piece of paper waived as a warrant, and one woman's conviction to make it real in a state courtroom. Step back from the facts, and the shape of this case is almost counterintuitive. The landmark that reshaped search and seizure law in every state did not begin with a dramatic confrontation. It began with a bombing suspect who was never found, a search that produced something else entirely, and a conviction that no one at the time thought would matter very much. And yet it did. Mapp, Gideon, Miranda. These three cases are not coincidences stacked next to each other. They are three pieces of the same shift: applying your constitutional rights to the states, making them real where you actually encounter the law. Miranda told police what they have to say when they arrest you. Gideon guaranteed you a lawyer if you cannot afford one. Mapp answered what happens when the police break the rules before any of that. The Fourth Amendment says the government cannot search your home without justification. Mapp is the answer to the follow-up question nobody asked loudly enough for decades. Or what? Or the evidence gets thrown out. That is the rule. That is what the case cost and what it bought. Next episode, we pull back further to who decides what counts as a crime in the first place and whether the law applies to the people who write it. Until then, now you know what it took to make the Fourth Amendment more than words.